Good evening, everyone. The September 7, 2017 Rent Control Board meeting is called to order. Would the secretary please take roll?
Excuse me, I didn't hear you.
Commissioner DeRosa's
Here.
I turned my mic on.
I wasn't sure you were saying my name.
I was, but I didn't have my mic on. Commissioner Foster.
Here.
Commissioner Flora.
Here.
Commissioner Duran.
Here.
And Commissioner Phyllis is absent yet.
Okay, would everyone please join me in the salute to our flag?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, may I have a motion regarding the approval of the minutes?
So moved.
Okay, there's been a first. Is there a second? And by the way, this is the minutes for the August 10th, 2017 meeting.
Second.
Okay, there's a first and a second. We'll take a voice vote. All in favor of approving the minutes as written?
Aye.
Any opposed? The ayes have it. Moving on to our next item, special agenda items. Any reports for us?
Good evening, Commissioner. On October 10th, we're going to have a maintenance workshop in the main library and multipurpose room. That'll be on the 10th at 9:30 in the morning. This is a very popular workshop. It'll be presented as it has in the past with the city's code compliance division staff. And this seminar is going to address what types of maintenance and repair are required, how and where to file complaints, discussion about temporary relocation of tenants during repairs, and overall general issues related to habitability. Tenants, owners, managers, and other interested individuals are all welcome. If you're interested, please contact the Rent Control Office. The phone number is 310-458-8751 to sign up for this workshop on the 10th. The second item I wanted to bring to your attention, Commissioners, is a study session that's going to be happening on seismic safety retrofitting of rent control properties that will take place at the board's next meeting on October 12th. The board will hold a study session at the regular meeting to begin consideration of seismic safety retrofitting costs and whether some portion of the cost should be passed through to tenants. All interested parties are invited to attend and express your thoughts about this issue. This will be a beginning of a longer discussion that will involve additional opportunities to hear from property owners, tenants, and the general public. We will provide information about the upcoming study session on our website, as well as on the city's webpage that's devoted to the seismic safety program. The city will also be scheduling and holding public information meetings about the program, and the first one of those is scheduled for November 13th. We will be participating in those meetings, and that is the special reports for today.
Thank you very much. Any comments?
Mr. Chair?
Yeah.
Yes.
I'm sorry.
Hang on one second. I have
sorry.
Commissioner Trosas in queue. Commissioner Trosas.
Yes, thank you for that informative update. I have a couple of questions. First, pertaining to the item with the meeting with code compliance. I seem to recall when they were here several months ago, I had asked if staff could come back with information, or even if the neighborhood preservation coordinator could come back with information about the streamlined process between agencies, i.e. the Rent Control Board and Building and Safety, for facilitating the process when there's a construction-related decrease petition. I just wanted to know what came of our discussions with staff from Building and Safety and Code Compliance, and if any improvements have been made and what the status is. I want to make sure that we're not just saying that we're committed to streamlining the process, but that there are measurable gains and processes that have been put in place to help both the landlords and the tenants through this sometimes confusing process. So I was wondering if staff could come back with, or if the neighborhood preservation coordinator could come back with further information about what's been put in place since we last heard from them, and if there's a recommendation to move forward with any new changes or if the status quo is working. So I'd love to hear more about that. And then secondly, as it pertains to the study session for the earthquake retrofitting, I wanted to implore staff to come back at that study session with a robust plan for stakeholder engagement on this issue. I don't think having one study session at 7 o'clock on a Thursday night is going to be sufficient. I think that we need to reach out to both landlords and tenants to hear concerns, whether it's an appointed body, but I would like staff to look at other similarly situated jurisdictions as to how they've done outreach on this issue and come back to us with recommendations for robust community engagement, because I think this is a major issue, and I would like to hear from more than a few members of the public at a board meeting. I also think it's really important that we do outreach to landlords and tenants about what's currently happening and what hasn't yet been decided. For example, I was at a neighborhood meeting this week, and there seems to be quite a bit of confusion amongst the tenants as to when retrofitting might occur and if they're going to have to move out of their units. And I know that that's not necessarily our responsibility to do that outreach, but I think that we need to work with the city to make sure that rent control issues are featured on the seismic safety retrofitting website. It was reported to me that there's no mention of any sort of tenant protections or anything pertaining to tenants whatsoever. I also think we need to give landlords some options for financing packages on retrofitting. And I know that, again, that's not our responsibility, but these are just issues I think we need to consider. And I think we need to do a better job of outreaching to the community, especially as we're rolling this out, because there does seem to be confusion out there as to how this is going to be implemented. So those would be my comments.
Thank you, Commissioner Trosis. Commissioner Flora, you had a
Yes, two things. First, and I'm sorry, I was just a little slow with my note taking. The maintenance workshop date and time of day?
It's October 10th at the main library multipurpose room at 9:30 in the morning.
Okay, thank you. And I appreciate Commissioner Trosis, your passion on this issue, and I do hope that we really engage the broader public on the retrofit issue. But I've talked with our executive director, Tracy, who's not with us tonight, and this isn't going to be a one meeting issue. I mean, we're going to be talking about this for months. So that's something people should also know. And to talk about it for months, effectively, yes, we need to be doing some of the things you're talking about. But just so everyone's clear, October is not the only Thursday night we'll be talking about this issue.
Okay. Good evening, Commissioner Phyllis. You'd like to say something?
Good evening, Commissioner Duran, fellow commissioners. I wanted to talk briefly about an issue that was recently brought to my attention. I think Commissioner Trosis is the other commissioner with whom I spoke about this, and I think she shares similar concerns. We've been informed, and it would be helpful if staff could verify what's going on, that the Ellis study that was commissioned at the request of the Rent Control Board to City Council has actually been completed, and that the initial presentation will be to the Housing Commission and not to the Rent Control Board, which seems really strange given that we were the body that went to City Council and requested. So I have a couple of requests. One, if the report has been completed, I would like to know the contents of the report and when it will be presented to the public. Two, if there's going to be a public meeting on it, and it's already been agendized before the Housing Commission, then it should be a joint meeting of the Housing Commission and the Rent Control Board. Yeah. I mean, this is like a no-brainer. I feel really strong about it. So I would direct staff, if the Housing Commission has already agendized it, to coordinate having it be a joint meeting, assuming that there's support for that among my fellow colleagues, because... And the Housing Commission, right? It would be a joint meeting of the Housing Commission and the Rent Control Board to discuss the housing, the Ellis report. I mean, I don't know how you can have a conversation about Ellis without including the Rent Control Board. So if that is the case, that's really concerning, and I want to figure out what's going on. Thanks.
Okay, got that. Commissioner Trosis, something?
Yeah,
new?
I just wanted to respond to Commissioner Flora's comments. I definitely understand and appreciate that this will not be a one and done process. I just want to make sure that when we're making a decision of this magnitude, that all parties who want to weigh in have been engaged. Because I certainly, maybe I'm the lone person, but I certainly would like to hear from all constituents of different mindsets. And again, I think I say this every month, I'm happy to meet with anyone who wants to talk to me, and happy to receive comments from anyone who wants to give comments on their thoughts on this or any other issues.
Yeah. I just want to make people aware that it wasn't just one night. That's all.
Okay, thank you very much. Moving on to public comment. I'm not sure, so I just want to ask. There is a request to speak, Ms. Elena Granell. You didn't indicate what agenda item you wanted to speak on. Is it during the public comment, or was it on one of the other agendized items? Okay. In that case, then I will say this.
Yeah, I was going to mention that.
Yes, okay, got it, just making clear. This is a time set aside for the members of the public to address the board on matters that are not included in the agenda, but that are within the board's subject matter jurisdiction. Please note that we cannot take any official action at tonight's meeting on any matter that is not included on the agenda. However, I invite anybody who's in the audience who wants to put in a chit to do so if they have any comments to make during this period in the public comment section. So having said all of that, we do have Ms. Elena Granell who has requested 3 minutes. So please come up to the podium, and whenever you're ready, we can start.
Commissioners, as Ms. Granell is approaching the dais, I believe you all know this, but she has also submitted something in writing that we have also passed out to you.
It's just a copy of what I'm going to say, and also a couple of supporting documents. And I just want to say, I hope that it wasn't inappropriate for me to include my landlord's tax bills. You know, I just thought that it was a good informational item, so you'll see that in the little packet that I gave you.
Thank you.
My name is Alana Grinnell. I live at 1025 105. It is a 21-unit building. I've lived in Santa Monica for 5 years in a rent-controlled apartment, and I am a senior citizen and a widow living on Social Security and my savings. Upon receiving my latest notice of change in terms of tenancy for 2017, I was shocked at the increase of my total rent. I accept the maximum increase of $40 and $8.25 registration fee, which was passed on to me, but I cannot accept the 400% increase in tax bill surcharges that I'm expected to pay every month as well. That brings my total monthly rent increase to $170. This increase is $2,040.96 annually. That's a lot of money. It's a big increase, and it's a huge burden on me. And I'm sure it's a huge burden on the other people in my building because we've discussed it. The building I live in came under new ownership May 15th, 2016. And I realized that my new landlord's property tax bill increased. Now I have the burden of paying a percentage of his increased tax bill due to the amount he paid for the building. Nothing has changed or been improved in my apartment or my building except for a paint job on half of the outside. As a matter of fact, we did not have a working elevator for 9 months until last month. Still have no access to our pool. But yet I still have to pay this huge increase as of a few days ago, July 1st. The reason I am here to speak to you today is to appeal to you to put a cap on property tax surcharges. we tenants have to pay it because I guess it's a law, and a law that the rental board put forward. There is a cap on the maximum allowable rent increase, but why is there no protection here on the tax surcharges? I've included a copy of my notice and a copy of my landlord's 2016 tax bills, so you can see the increase from last year's $30.31 to this year's $121.
Thank you very much.
Okay,
Ms.
thank you
Grinnell.
for your consideration on this matter.
Appreciate that. I have Commissioner Foster who would like to speak.
Yes, and I'll be brief. I want to thank you for your comments and for being yet another citizen who has brought this to our attention. And you may be unaware of other meetings where people have had similar commentary in public comment, but I just wanted to acknowledge that myself and other people in the city do recognize that there is a difference between what has been and then what speculative real estate can do to a market and can do to individuals' lives. And so I'm not going to comment any further tonight, but we just wanted to thank you for coming and giving a concrete example of what you're experiencing, and just want you to know that you're heard.
Thank you very much. Okay, moving on to item number 10, the jurisdictional items. I have here an exemption case E1756 with the address 2711 Euclid Street, and the applicant is Mr. and Ms. Hagar. May we have a staff report, please?
Commissioners, before we begin, we have a late written response to the staff report that was submitted by the Hagars, or the owners and the applicants for this exemption. You will have to first decide whether to accept this untimely submission. The staff report was mailed to the Hagars on the 25th of August, and the deadline for any written response was Tuesday afternoon. The Hagars submitted this response only this morning, more than a day past the deadline, and the response also contains photographs which can constitute new evidence that was not submitted to the hearing officer for consideration. Because the response was filed late, the staff recommends that you do not accept it.
Okay, my inclination is that the deadline was set up as to when they could submit their information. We are an appellate body, and we're supposed to review the complete package of evidence up to a certain point and rule upon that. So this being after that time, I'm inclined to deny it, but I'll listen to other commissioners.
If I may just make a point about what you just said, Commissioner.
Yes.
In this case, you are not acting as an appellate body. This is actually a recommendation from the hearing officer. But what is also true is that the hearing, which is an evidentiary hearing that allows the hearing officer and other interested parties and witnesses to provide evidence to what's being presented at that hearing, did not include the pieces of evidence, that photographs that have been attached to the late response.
Okay, thank you. Thanks for clearing that up. I appreciate that. I have Commissioner Foster who'd like to say something.
So while this board often stays late into the evening, always willing to hear from the public and always willing to hear public comments and evidence as it's appropriate to hear, I also don't feel that that new photos introduced at a late date or de novo evidence would be appropriate to hear at this time, and I'm comfortable that the staff report is thorough at this point in time. And I'm curious, to what address was the hearing officer's report mailed to?
I'm going to look at the proof of service, Commissioner.
Because the reason I'm asking is there have been two addresses in in
The
play?
proof of service shows that it was mailed to the Euclid Street address, which is the address that's at issue here. It was also mailed to the Hagars at their place in Palm Desert, and it was also mailed to their condo that Mrs. Hagar owns in Van Nuys.
Well, thank you for that, because having mailed it to 3 addresses, I just think we're bound by the law to limit what we hear new. Thank you.
Okay, Commissioner Phyllis.
I might be a voice in the forest on this one, but this is a couple that has had significant health issues, and I'm interested in seeing what they have. I think that if there's ever a circumstance in which there would be a reason to consider a late filed submission, this would be it. I also think the fact that we are not sitting as an appellate body is significant. The fact that we are sitting here deciding whether to adopt a report and recommendation means that we're the fact finder. And I think, this is an issue that's come before the board before. This is an issue that I think the board found very sympathetic and could be a close call. And I think that we should see, and I would like to actually just know what the standard is from staff as to whether we should accept new evidence or not, because I think it's is it abuse of discretion, or what is the?
In this situation, it's different than the other situations, right, where there's a standard. And what we're talking about here primarily is actually a late written response to the staff report, to which is attached this photographic evidence. If you accept the photographic evidence, you can certainly accept it, and there's nothing to preclude you from doing so. But it would certainly not be things that have been analyzed, subject to cross-examination, or any other similar kind of things that would happen in an evidentiary hearing.
Okay, I understand. So just to my fellow commissioners, what that says to me is we're going to have to make credibility determinations if we choose to accept this evidence, and it's going to have to be with the caveat that we are doing it on the dais. That said, this is a couple that has had significant health issues, that did have a close call before. I think that absolutely justifies a fact finder hearing this evidence. These are somewhat more relaxed, informal proceedings than a traditional court, and I see every reason, and I strongly urge my fellow commissioners to accept the new evidence.
Thank you. Commissioner Trosis.
Yeah, can you just say, was there a reason given as to why this was late submission?
I do not believe that the, if I may ask, Lonnie, can I see one of the...
I just wanted to know, because I'm thinking similarly to Commissioner Phyllis, but if there was a legitimate reason or a credible reason as to why it was late submission.
She actually, I was the one that took the evidence from her, and I asked her, and she had indicated that she had planned on being here this evening, but something came up in her schedule, and so she felt she needed to add that her husband is here tonight.
Okay. So. With that being, I think that that's relevant to me. Again, if I'm reading this correctly, we're reviewing this for preponderance of the evidence. Is that correct? Yeah. I think I'm comfortable in making a determination as a fact finder to admit the new evidence into the record for us to consider, especially given the fact that she was going to be here and now is not able to be here. So I'd like to see all the evidence. And I'd also like to note I was not here when the previous decision was heard. So this is the first time that I'm looking at this.
Okay. Commissioner Flora, I think you're the only person who's not spoken as to this yet.
Right, so I need my turn, right?
Absolutely.
I've always been willing to take correspondence and things that have come late. One of the things that I think maybe what gets me is the new evidence part. And that's really why I would defer to probably not accepting it, because I think we should stop getting into the habit of letting new evidence be introduced the night of, reports that have been completed. So I'm not adamant about it. I just am not as comfortable about it as other commissioners might be. But let's keep it going here.
All right. I'd like to just call for the vote as to whether we should admit. I think everyone's had a chance to speak on the issue.
Well, I'm going to move that we accept, and I'm going to speak in support one more time as to why I think we should accept accept the evidence, specifically responding to Commissioner Flora's comment about new evidence. Look, this is a short meeting tonight. We don't have a lot on the agenda. We have, we pride ourselves in encouraging public participation and hearing people, and there's absolutely no reason for us not to accept this evidence other than a absolute strict adherence to a rule. Now, this rule I want to contrast to something on appeal, where when you're on appeal, you have a sealed record, right? You have every argument that's been made in a lower court or lower hearing, and those arguments have to be the basis for the appeal. That's not what we have here. What we have here is an initial determination based on a report and recommendation of a fact finder. We are sitting as the fact finder, so this isn't really new evidence in the same way that it is on an appeal. It doesn't present the same issues.
Okay. Commissioner Foster, go ahead.
So when I first spoke, I was misunderstanding. I was thinking we were sitting in an appellate. I mean, initially, I was assuming we were sitting in more of an appellate fashion where we often are not able and where the prior record is sealed. So I appreciate your clarification on that. And because I've also heard from Commissioner Terosas' question that this would have been something that a person with the right to speak to the case would have probably presented during those comments, I'm changing my mind in this particular case. Although I do agree with Commissioner Flora that constantly, this does not mean that we would constantly agree to see new evidence, because there's respect for the process and respect for deadlines in place. But since this person probably would have brought up these arguments tonight anyway, I'm now inclined to take the evidence.
Commissioners, if I could just add, if you look at the regulations that pertain, if the board agrees to receive new evidence and the applicant agrees to waive time deadlines, the board may refer the matter back to the hearing examiner for presentation of the evidence and preparation of a new recommendation. That will not necessarily be something that you want to do because of the nature of the evidence may not warrant that, but you certainly have that option available to you.
To remand?
To remand, to review the new evidence that's being submitted for a new recommendation.
And we can do that at any time, so we can see the evidence, deliberate, and then ultimately decide to remand back to the hearing officer if we feel like it's a close call, right?
Okay.
And if should you remand it, then you also would need the applicants to agree to a waiver as well and to execute a waiver. Okay.
Okay. So in light of that information, I believe that there's been a motion by Commissioner Phyllis. Do you want to amend your motion?
No, because it'll occur during deliberation whether we want to remand it or not. So it's just straight up admit the evidence and accept the newly admitted evidence.
I'll second.
Okay. There's been a first and a second. We have to do a roll call vote on this?
You may want to on this one.
Okay. Yeah, let's do a roll call vote.
Commissioner Foster?
Yes.
Commissioner Flora?
Yes, persuaded, yes.
Commissioner Phyllis?
Yes.
Commissioner Terosas?
Yes.
Commissioner Duran?
No.
Motion carries.
Okay.
So Mr. Gwynn will pass out the evidence that's been submitted and this written response.
Thank you. And
Mr. Chairman?
Before we have the staff report, can we just all have...
Yeah, why don't we take a couple of moments, if we can, to review this?
Mr. Chair?
Yes.
If I may, by accepting the evidence, if there is someone here to speak to the item, they can now speak to new evidence as well.
Well, my
correct?
understanding is the person who was going to present this is not
They're
present.
not going to be here, okay.
Is Mr. Hagar going to speak?
Yes.
Yes, he will speak? Yeah.
Okay, my understanding was that this was from Ms. Hagar. Is that incorrect?
The letter was written by Pamela,
Okay.
and the photographs were taken with her device. I have not seen photographs, but I'm, taking photographs of us in the house.
Okay.
The house and cars and everything. So I've read her.
Oh, all right. No, that's fine. Thank you. I just wanted to know if you did.
Give him a copy of this too. Yeah.
I'm wondering, commissioners, shall we recess for a few minutes so that we have time to read this?
I don't
Is
know
that-
we need to recess. We can just do it on the dais.
Just
Okay.
realize that you're on TV.
Yeah.
Yes.
Do we,
Maybe some background music, elevator
Yeah.
music in the meantime.
just some uncomfortable silence? I'm sorry.
And in my presentation,
Oh,
I would speak to that.
Okay, that would be fine. Thank you. Could we do it? Would it be after? Would it be after? I think the other ones are in book quickly. We'll do it after jurisdictional items are closed. Okay. Okay. My fellow commissioners, have you all had ample time to review? Okay. Moving forward, then let's have a staff report if we may.
2711 Euclid Street is a 3-unit property that's owned by Philip and Pamela Hagar, and the board exempted this property from rent control previously because of owner occupancy. Mr. Hagar began experiencing significant health problems in 2014, which caused him to move to Mrs. Hagar's condo in Van Nuys because it had already been set up to accommodate a person with limited mobility, specifically Mrs. Hagar's mother, before she passed. Because the Hagars no longer lived in the Santa Monica property, the matter was referred to a hearing officer to determine whether the exemption had lapsed. Eventually, the matter reached the board, who concluded in June 2016 that the Hagars had failed to prove that the Santa Monica property was still their principal place of residence. The exemption had lapsed. The Hagars contend that they moved back to the Santa Monica property since at least January 22nd of 2017, and they reapplied for the exemption of the property as an owner-occupied property. The tenants on the property told staff that the Hagars have not lived on the property since that time, which is what they must prove to qualify for the exemption in this application. The matter was referred to a hearing officer who concluded that the Hagars failed to show that they had lived at 2711 Euclid since January 2017 as their principal place of residence. Because the record supports the hearing officer's conclusion, staff recommends that the board adopt the recommendation and deny the application. The evidence in the record shows that at best the Hagars have carried on their basing living activities at 2711 Euclid since only June of 2017. Jane Richardson, who is the tenant in Unit B, testified that she works from home and can tell when the Hagars are home. She stated that they leave the lights on to make it appear as if they're there, but she can tell that they're not. The Katzes in Unit C also testified that the Hagars don't live on the property, although they said that they had begun to see them with greater regularity since June 2017 after they had filed their exemption application. The Hagars admitted that they do leave the lights on when they're gone. They insisted that they had moved back since before January 22nd of this year, and they submitted photos to show Mr. Hagar in the unit. The photos, however, were dated no earlier than June 19th. A friend of theirs submitted a statement that that person had picked up Mr. Hagar from their apartment on May 23rd of this year. And the Hagars also offered a series of proofs of personal mail delivery to Mr. Hagar at the Santa Monica property, but the earliest was dated June 14th of 2017. The hearing investigator visited the Hagar Santa Monica apartment. He stated that compared to when he had visited last year during the lapse hearing, the apartment was now decluttered and appeared much more navigable for Mr. Hagar, and the refrigerator had been repaired and contained perishable items. But the hearing officer also testified that despite multiple calls in June 2017 to schedule the site visit, the Hagars did not schedule the inspection until July 10th, nearly a month after his initial call. The hearing officer reasonably inferred that the significant delay would have allowed the Hagars to rearrange the apartment to make it appear as if they lived there. The Hagars similarly delayed the site visit to their condo in Van Nuys. That they had the condo and had been staying there during Mr. Hagar's rehabilitation was a significant factor in the board's prior conclusion that their exemption had lapsed. A month after his initial call, the hearing investigator visited the Van Nuys condo and observed that it was still fully furnished with food, medication, supplies, and personal property. Mrs. Hagar explained that the personal items had been there from when her mother had been living there, and that many personal possessions belonged to her caretaker, who still had access to the unit. And the investigator did observe mail addressed to that caretaker, and one of the bedrooms contained her possessions. but he said that the plants in the condo appeared to be well taken care of and the freezer was fully stocked. At best, the evidence that was in the record related to the condo is inconclusive, particularly given the delay in the inspection. Other factors do not conclusively show that the Hagars have lived at 2711 Euclid Street since January 22nd. Mrs. Hagar has a homeowner's exemption for the property, none for the Santa Monica property. Mrs. Hagar is registered to vote in Santa Monica. Mr. Hagar is registered to vote somewhere outside of Los Angeles County. Utility and financial bills are mailed to the Santa Monica property, but this had been the case during the lapse hearing last year as well. It's also not inconsistent with the tenant's testimony that the Hagars visit the property periodically to pick up mail, but that they have not lived there since January 22nd. Given this record, the hearing officer concluded that the Hagars have failed to meet their burden of showing by a preponderance of the evidence that they have resided at 2711 Euclid as their principal residence since at least January 22nd of this year. Staff believes that conclusion is a reasonable one given the record and recommends that the board deny their application and adopt the hearing officer's findings of fact and conclusions of law.
Okay, thank you very much. Commissioner Flora, did you have questions regarding the staff report?
No, not before the speakers.
Okay,
I'm just
very
sort of
good.
putting in an early chit for
I
myself.
understand. Very well. Okay. In that case, I have one request to speak from the applicant, Mr. Philip Hagar. If you'd like to come up to the podium. You've requested 5 minutes.
Is this me? You hear me?
Yes, we do.
Okay.
Whenever you're ready to start.
Very good. First, given my health problems, I was we were residing or staying in Van Nuys for months. 14, 15 months straight. But the intent was not to live there. The intent was, because I was hospitalized over at the hospital in Van Nuys, I came back there to rehabilitate. And I could have rehabilitated in Santa Monica. But there was an inclinator up there, a hospital bed that I could stay in the main bedroom. And it was just convenient to be there. And Pamela, has a feeling, her mother lived there and had a fatal injury there and passed away in an emergency room. And so she is emotionally tied to that unit. And she's finally discovering that she needs to sell it, for sure. Anyhow, we moved as soon in 2015, late or early 16. I got a request from a staff member of the Rent Control Board to provide documentation that I was there, and I sent him certain items. He said, but that's not enough, so we're going to request a hearing. So at that hearing, I think in June 1916, the hearing officer recommended we keep our exemption. You know, so we've been doing this dance for some time, going on 2 years. By the end of the early next year, it'll be 2 years. But we moved back as soon as we understood that we were going to be confronted. I didn't have to live there. I mean, I can do this rehabilitation in Santa Monica, and I'm quite happy. I mean, there's lots of stairs in Van Nuys. There's 8 stairs to get to the front door, and there's 12 stairs to get to the second floor. And I negotiate those. You know, even in a rehabilitating condition. So, given the hearing officer's recommendation in early 16, spring of 16, and the staff report in 2016, both recommended that I keep the exemption, or Pamela and I keep the exemption. But the board, in its own wisdom, took it away. So the question I have is, you know, you have a staff, you have a hearing officer, you have a staff, and they make recommendations, and you have recommendations tonight for other applications. Why have a staff and hearing officer give you recommendations if you don't seem to want to follow their recommendations? And after the second question, that's the first question. Why would you go against the recommendations? First question. The second question, why after 17 years of living from 1997 until 2014-15 of having this residence, why would 10 or 15 months negate that just for medical and rehab reasons? Why would that? That's a second question for the board. Thank you. Oh, and thank you for accepting Pamela's evidence. That was very nice.
Thank you, Mr. Hagar.
But we went against the staff recommendation. Just saying. That was against the staff recommendation. We did something. Yeah, no, he's saying he doesn't appreciate that we go against the staff recommendation, but we accepted it against it.
That was in 1916. Back then.
Okay.
Anyway, whatever.
Yeah. Commissioner Torosis.
Yeah, I have some questions. Thank you for your testimony and for coming tonight. Apologies. Okay, so I've actually read the staff report. I looked at your underlying file. I looked at all of the pictures in the file. I also looked at what you just submitted to us tonight. I guess my first question is, like, have you brought any witnesses? Did you bring any witnesses to the initial hearing? Did you bring any witnesses tonight to corroborate what you're stating?
Witnesses.
You stated in here, for example, Ben, the mailman, sees you every day, that there are people that see you in the unit in Santa Monica. Is there anyone to back up what you're stating tonight?
I brought no witnesses. I didn't bring the mailman or my neighbors. I guess I could have.
Okay.
I didn't think it would be necessary.
Just so I'm clear, none of the neighbors are here to offer any comments, correct?
I don't have any other requests to speak on this matter.
Why do you think that the neighbors would say that you don't live there? The tenants. Excuse me.
Those are the tenants.
Why would the Katzes or Mrs. Richardson say you don't live there?
Well, it would be in their best interest for me not to ever receive an exemption.
Okay.
That's the reality of it.
But you asked us, why would you go through all of this trouble? But yet you're admitting that it would be in your tenant's best interest for you not to receive the exemption.
Because I want freedom.
Okay. Why was it difficult for the staff to schedule an inspection at the unit?
Well, there's two reasons. I refused to meet with Little Pete, and Pamela's got her work constraints and other issues that keep her from meeting when he wants to. That's basically it. I mean, it was not because anyone was doing anything to change the look of the house or Van Nuys or Santa Monica or anything.
So you weren't out of town or potentially changing the makeup of either unit in June 2017?
No.
Okay. You just don't.
No. This was for the inspection for this issue.
Correct.
No, but Pamela's got work issues where she just can't leave, and I don't want to go to Van Nuys with this.
How long were you? I think you might have stated it, but just can you tell me how long were you living in Van Nuys before you decided to return back to Santa Monica?
I don't know exactly how many months it was, but I'd have to go back and do the historical record of my hospitalizations, my rehab appointments. I figure somewhere between 11 to 14 months, maybe.
Okay.
That's in my recollection.
Okay. Those are all my questions for now.
Thank you. Commissioner Phyllis, do you have any questions for Mr. Hagar?
I don't, but I was hoping to move into discussion.
Yes, okay. So let me ask Commissioner Foster, do you have any questions for Mr. Hagar?
No.
Okay. Neither do I. So thank you, Mr. Hagar, for speaking tonight. At this point, we will move into discussion on this
Do you
matter.
have any questions on the evidence?
No.
No, we don't.
Okay.
Yes, I think it was already asked. Thank you very much, Mr. Hagar. Okay, Commissioner Phyllis, go ahead and open discussion if you would.
So, well, I think that, this was a difficult case when it first came before us, and it still is a difficult case because this is a family that's obviously gone through some major life events, some major illnesses. We have a lot of, I think, a lot of sympathy for the fact that these are real people who are going through real things, and we do understand that. But the issue before the board is, have they produced sufficient evidence to warrant a finding that they lived there since January 2017? And I think I agree with the hearing officer's finding that at best we're talking about June 2017. I haven't seen anything from the new evidence to suggest that it goes back before, to rebut that it goes back before June 2017. And honestly, I do think there are credibility issues. We've heard kind of inconsistent testimony even here tonight about the justification for why the hearings were delayed, both in Van Nuys and in Santa Monica, why the inspections were delayed in Van Nuys and Santa Monica. These exemptions have real impacts both on the landlords and the tenants. And since I've come on the board, they're not something that I've ever taken lightly. I mean, I remember pushing really, really hard for the recertification process because this was exactly the type of situation that was intended to be detected. So, I think that if the tenant can demonstrate, or if the landlord can demonstrate that since June 2017 they have lived there, then they want to reapply for the exemption when they're eligible again. so be it. I think that was the sentiment expressed in Ms. Hagar's letter. That seems fine. As soon as you qualify for the exemption, we are not going to deny you something to which you're entitled as a matter of law. But to me, the preponderance of the evidence doesn't support conferring an exemption at all right now.
Thank you, Commissioner Phillips. Commissioner Foster.
Thank you. And at the original hearing of this case, it was significant to me, and perhaps staff can remind me. I know we're on limited staff tonight, but and it's not in the record, but I had asked at the last time we heard this case that while they were definitely living in Van Nuys for a year and a half or more, had they availed themselves of rent increases on the tenants who remained behind at the property that was ostensibly under an owner occupancy exemption and therefore free from any of the encumbrances of the general adjustment. I did ask that question, and you did answer that in the letters from the other tenants, and so that the rent had been raised substantially. And the purpose of an owner occupancy exemption is because the owner is in residence, is clearly in residence, and wants to live there and enjoy their home and to control their surroundings. And I work with seniors. I work with seniors for a living. I work with rehab and physical therapy and assisted living, and I am not in any way, shape, or form unsympathetic to what a person's home means to them. And when they're not able to be there because maybe adaptive equipment might not be enough for even a certain set of steps or something else, I am not in any way unsympathetic to the desire to come back, but the standard of the law for me is that if you're not able to come back, that is what matters in fairness to the tenants who do remain on the property. And so I am inclined to deny the exemption.
Thank you. Okay, I have a couple of comments. I'll start by saying that I agree with Commissioner Phyllis's assessment of the facts as they are presented so far. I agree that I do not think there is a preponderance of the evidence of facts that show that they are tenants for the period of time that they were required to be in order to get the exemption this evening. If they are, if they live there and they're able to show on another go-around evidence by a preponderance of the evidence that they do live there, then I think that this board would probably have a different decision, or make a different decision, I suspect. But there are a couple things that I just wanted to highlight as for my reasons. And one of them was in the report, the mail that was sent to the Hagars at the Santa Monica property was returned. The testimony that was provided by the tenants in Unit C and Unit B indicating that they had not seen the Hagars there in that time period that was required was persuasive to me. And also, in my estimation, the lack of facts that the Hagars had regarding the frequency with which that they were there to me adds up to not having the preponderance of the evidence needed to garnish this exemption. Having said that, I am open, I think, as Ms. Phyllis, as Commissioner Phyllis is, to hearing this at a later date when in a reapplication, when all the steps are followed and that there is a showing by preponderance of the evidence that they are there. I just think that at this point it's not there. Commissioner Flora.
Thank you, Chairman Duran. Commissioner Phyllis mentioned that this is a tricky case and has been a tricky case from the beginning. Exemptions shouldn't be tricky. They should be slam dunks, and this isn't a slam dunk. And so that's why I would agree with my colleagues thus far that, you know, while I am very sympathetic and sorry for what this family has had to go through and the moving about the county, it's just not there yet. And that's okay. That's not accusing anybody of anything. It's just not there yet to fully prove that this privilege should be granted. So I'm with you and Commissioner Phyllis right now.
Okay, I have Commissioner Trosis.
Thanks. I mean, yes, rent control is put in place to protect the tenants in their homes and to ensure that people have a place to live that's available and with some assurances, somewhere that they can stay for a significant period of time without having a de facto rent increase such that the tenant would have to vacate because they can't afford it. So I think I agree with Commissioner Flora that we do need to take this quite seriously. And to me, preponderance of the evidence, more likely than not. That means that 51% of more of me needs to be convinced that more likely than not, since January 22nd, 2017, the Hagars were living as the primary place of residence in Santa Monica. If I'm 50-50 and I'm not sure, I have to deny the exemption. And at this point, at best, since June, the Hagars have resided in Santa Monica, but I do not see any convincing evidence either in the record or even in this new evidence, which, by the way, does not have dates on the photos, that more likely than not the Hagars were living in Santa Monica since January 22nd, 2017. And so for that reason, I have to deny the exemption.
Okay, I'll entertain a motion. Okay, Commissioner Phyllis?
I have a motion here, and then I do have a motion after, but they're unrelated. So I move that we deny the exemption. Without prejudice, obviously, they can come back.
Of course. Second.
Okay, there's been a first and a second. No further discussion. We'll take a roll call vote.
Commissioner Phyllis?
Yes.
Commissioner Flora?
Yes.
Commissioner Foster?
Yes.
Commissioner Trosis?
Yes.
And Commissioner Drawn?
Yes.
Motion carries.
For my second motion, Commissioner Drawn, I want to kind of draw on what Commissioner Flora said before, that exemption should be easy calls, and the remaining 3 applicants, I believe, are super clear calls, I think. And depending upon the interest of my fellow commissioners, I would move that we grant them by consensus.
Second.
Okay, there's a first and a second, and I would agree with that based on the reports that we received. I think you're absolutely right. These are slam dunks. There is a preponderance of the evidence that all of the elements for each of the cases were met, and I think it's all there in the reports. So I would concur.
I have a comment. Was there any public testimony as to any of these?
Thank you. That's a very good point. There are no chits that have been submitted on any of these, which...
Okay, so they're not in dispute. Okay.
Yes, I agree.
I would agree with
Okay. Does anybody want to make a motion?
I think you
It's already been
moved.
done.
Yes.
Oh, yeah.
So, yeah,
Thank you.
And who seconded?
I did.
A first and a second. You're very well. My memory is gone. It's been a long day. Okay, no further discussion. We'll take a roll call vote.
Commissioner Foster?
Yes.
Commissioner Trosis?
Yes.
Commissioner Flora?
Yes.
Commissioner Phyllis?
Yes.
And Commissioner Duran?
Yes.
Motion carries.
And there is one more item I want to bring before the board. There was a late chit that was submitted for public comment. I'm inclined to allow the person who's requested to speak, but I am asking my fellow commissioners if it's okay that a speaker come up and
it
speak.
was public comment?
Yes, it was for agenda item number 7.
I have no problem with that.
It's fine.
Okay, I think the ayes have it. So, Marion, I believe it's Dalk or Dalkey? Yes. Okay, come on up to the podium, and we're going to reopen the public comment section to take your comments. You've requested 3 minutes. So whenever you are ready. I have no chits for other public comments at this time.
I am both very low income and handicapped, and I was approved for Section 8. It took forever, but I was approved by Santa Monica. Anyway, Roque and Mark, at first they said they would accept the Section 8 agreement. However, when they got the paperwork
from the Section 8, there was a sentence in there, and they wanted a clarification from rent control. And I did speak to, what's her name, Beth Lederpack several times. She said she had returned, she said she had submitted it to your legal department, and they never got back to me. They did not get back to Roque and Mark. And I was then disallowed by Roque and Mark because they could not get a clarification from rent control. The sentence in the way the law is written, apparently from what Roque and Mark told me, was that my rent is $900, and with the Section 8 it would have gone up to $1,800, so the owner would have benefited, of course. However, if I should lose the Section 8, then it would have reverted to its original lower rent, and that was okay with Roque and Mark. However, they said at that point that if the apartment were put out if I left and the apartment were put out, that they would be stuck with this lower rent, the way the law is written. And we could not get, I couldn't get it. I was over there several times. I called several times. Roque and Mark got no answer from whomever makes these decisions in rent control. I don't know how many people you have in your legal department, one or more, but they would never give us an answer to a clarification of that one sentence in the law. And so I lost it. Anyway, this is several months ago.
Okay.
So I lost the Section 8, and
thank you.
So what can I do? I mean, do I have a recourse? Can I submit the paperwork to you or whomever who should I have submitted to? Okay,
thank you. I would recommend that you speak with legal counsel that's here tonight after this meeting, and he can give you some advice as to what your next steps should be. I didn't want to cut into her time. I don't know if she has more time available.
She does, yeah.
Okay. Are there anything else you want to say about it?
No,
Is
just
okay.
that. I mean,
okay.
I'm gonna, if I can, I'm gonna have to start that Section 8 application all over again, and it took them forever, and it may be closed now. I'm not sure.
Okay. I have a request to speak, Commissioner Torosis.
I was just unclear. Can you tell me what provision of the lease or what sentence are you referring to that they needed clarification from rent control on? Can you just tell me the gist of it? Because Santa Monica.
Yes.
Oh, sorry. Go ahead.
When I leave, if I should leave, then they said they would. And excuse me, let me back up a little bit. If I lost the Section 8, this is a Section 8 that applies to that residence only.
Right. So it's project-based Section 8.
Correct.
Yeah.
Yes.
Mm-hmm.
And if that should be not funded by Santa Monica, and then they would have to, Roque and Mark would have to go back and give me my original lower rent control rent. And that was okay with Roque and Mark. But they said that then they felt that if I left voluntarily or I died or something, they would be stuck with that lower rent control number, and they would not be able to raise it to what did you call it? Market rate.
Right. Okay. That's interesting. I definitely think that I think the underlying document would be helpful, and you should definitely speak with our counsel, because that seems bizarre to me. I know that several jurisdictions in the county, including Santa Monica, have very strong anti-discrimination provisions, and I just want to make sure this was upheld in court, that source of income discrimination is prohibited per Santa Monica ordinance. So if there's any potential, again, I'm not stating any sort of legal advice or anything to that effect. I can just tell you we have an ordinance that prohibits against this type of discrimination if it's based on your source of income, i.e. on the fact that you're using a voucher to pay for your rent. And so I want to make sure that we're very clear on that, which is why I definitely would direct you to talk to staff about this, because I'm personally interested in knowing what happened here, and I'm sorry for this situation.
And also, if you could bring the document so that we're crystal clear on exactly what it is you're referring to.
I will.
Okay.
And if there's anything, obviously, that we can, do to assist in expediting your current situation, I think we're happy to talk to you about that.
So
very good.
Yeah.
After the meeting, I'll come.
All right.
Thanks for bringing it to our attention. I'm definitely concerned to hear about that.
Thank you. Commissioner Foster, you had requested to speak.
Ma'am, I have a couple of, ma'am?
Oh, yes, sorry.
Just a moment before you go. So did you also approach the Housing Commission in any way, or the Department of Housing who issues the vouchers in regards to this question that this landlord had? Or just the Rent Control Board? And was that because Roken Mark recommended you go to the Rent Control Board?
No. Let's see. The person I was dealing with at Rent Control, at Housing thing, retired, and he was his position was taken over by somebody named Patrick Gregorian. He's new, apparently. The person I was dealing with before said there's nothing I can do because Roken Mark can refuse it.
No, they can't. They actually cannot refuse it. So, I think we'll let you talk to staff after this, but I just want to say for the public's clarification that we do, both in rent control and in our Department of Housing and our city government, have very strict rules designed for fairness regarding Section 8. And Roken Mark, I think as everyone in town knows, is a long-standing landlord with decades of experience and multiple buildings, and that is something that I'm not so certain they should have placed solely on your shoulders to find out. It could have been an equal case, and I, just like Commissioner Trosas, I will be closely following the trail of this situation, and we're glad you came tonight to bring it to our attention.
Thank you.
Thank you very much. Okay, there's no other speakers. I'm closing the public speaking section again.
Move to adjourn.
Okay.
Second.
First and a second. All in favor?
Aye.
The ayes have it. We'll see you next month. Thank you. Good evening.